House File 10 is exactly the same bill that was authored by Majority Leader Pepin last year and that all of you who were here last year voted for. This bill is necessary to ensure that workers are safe in their workplaces. As the Me Too movement has highlighted, we need to change workplace behavior. It's my understanding that this bill originated as a result of testimony that Pepin and other committee members heard as part of the Harassment and Workplace Committee that was convened last year. And what we're trying to do here, and what you did last year when you voted for this bill, is to return the law to what it was when the legislature enacted it in the 80s. Although it's not in statute, the courts have essentially asserted severe or pervasive requirement into the sexual harassment statute. In Minnesota, this has meant victims not getting their day in court, but instead having their claims rejected on summary judgment. Severe or pervasive is such a high bar that things like unwanted kissing, unwanted touching, comments like "I want to eat you," and comparing female employees' breasts are not considered severe or pervasive in our state. These facts are all from Minnesota cases where summary judgment was granted to the employer, so victims never got their day in court. And of course, we don't even know the number of victims who were told that their cases shouldn't be pursued because they would never be able to even establish that sexual harassment was severe or pervasive. And I just wanted to quote something that was in a MinnPost article last year from Majority Leader Pepin. She said, "Appeals in courts often end before they even begin. Lawyers talked about how they would have potential clients and they would outright tell their clients, well, this isn't enough. This is not going to even be a case," said Pepin. "The severe or pervasive level makes it nearly impossible, if not impossible. We are pretty shocked by some of the cases that we read of harassing behavior that happened, and there was no opportunity for someone to have their day in court." Now, I anticipate that you're going to hear from opponents who will claim that the sky is falling with this bill, but I ask you to keep three important things in mind. First of all, an employee needs to report a claim. Second of all, for claims that an employer is unsure about, they can seek technical assistance from the Minnesota Department of Human Rights, and I specifically asked that of our human rights testifiers when they were here explaining what their job is. But most importantly, when an employer is presented with a claim, they will avoid liability if they act reasonably in response to that claim. This bill incentivizes employers to act, and if they do, they won't be liable. And finally, I would just like to note that a fiscal note was prepared and concluded that there is no fiscal impact.